All right, we are back on the record in State versus Jessy Kurczewski, case number 21 CF 885. Appearances, please.
Randy Sitzberger, Abby Nicolai, and JJ Crawford for the state. Good afternoon.
Donna Kukler and Pablo Galaviz are here with Ms. Kurczewski. Good afternoon.
Good afternoon to everyone. We are back on the record so that the court can give the decision on the request to include assisted suicide as a lesser included offense. I've had an opportunity to look again at the jury instruction for assisted suicide. I reviewed the instruction for first degree intentional homicide. I reviewed the special materials to the jury instructions in Wisconsin, specifically special material 6, which is all about lesser included offenses. I've read through the statute, which is 939.66. Although I had referenced some out-of-state cases, and while I did look at the Mississippi case, I didn't really go much beyond that. Wisconsin has a very specific statute when it comes to lesser included. Clearly, Mississippi allows instructing a jury on lesser non-included offenses under certain circumstances. Frankly, I think our homicide section of the lesser included statute is a similar type of mechanism where it's special circumstances where it's not so important that we look at the elements test, but they're still different from my perspective. So I read it. I thought it was interesting, but doesn't really have a whole lot of persuasive value on anything that I'm doing here today. I re-reviewed the motion from the defense, and of course, I considered the arguments that were made by the parties. So I briefly became aware that there may be a late filing related to this. I have not had an opportunity to review it, and I'm not going to take the time at the moment. I believe both parties had a full opportunity to present whatever arguments they wanted at the time, and that will simply be there for potential appellate purposes. So I want to start with the statute because obviously that's the first place this court needs to look, and that's 939.66. Sub 1 would be one particular well, let me back up. The statute says that the court has authority to include an instruction on lesser included offenses under certain circumstances. From my perspective, after reviewing that statute, I believe this court need only look intentional homicide are intentional offenses. And so that subsection isn't applicable either. So I focused on 939.66 sub 2. And as the parties are aware, this court has to consider a two-step analysis when reviewing and deciding a request to include a crime as a lesser included in the jury instructions and so instruct the jury. The first issue this court has to address is assisted suicide a lesser included offense of first-degree intentional homicide? And then secondly, is there a reasonable basis in the evidence for a jury to acquit on the greater offense and convict on the lesser offense? As we know, some courts have overlooked or said we don't need to address the first question because they answer the second question in the negative. But I think it's important in this particular case to look at both of these questions. And so the first question that I looked at is assisted suicide a homicide? And it's really important that the language of the statute be followed. And so when you look at 939.66 sub 2, it says this, and I'll preface it by saying the very first part, so above sub 1, sub 2, etc., says, upon prosecution for a crime, the actor may be convicted of either the crime charged or an included crime, but not both. An included crime may be any of the following. Sub 2, a crime which is a less serious type of criminal homicide under subchapter 1 of chapter 940 than the one charged. And I believe another way of asking this question is assisted suicide a homicide? And for reasons that I will explain, I believe, and we'll so find here today, that it is not. First of all, when looking at the plain language of the statute, the statute could have read, instead of a crime which is a less serious type of criminal homicide under subchapter 1, if it had said a crime which is a less serious crime under subchapter 1 of chapter 940 than the one charged, the inquiry would stop and the answer would have to be, yes, it's a lesser included, but that's not what the statute says. And I need to give meaning to the entire verbiage of sub 2. So when looking at all of 940 and specifically subchapter 1, I noted that, and I think it's kind of a clue, if you will, to the legislative, not intent, but the meaning of the statute itself, is that 940.01, 940.02, 940.03, 940.05, 940.06, 940.07, 940.08, 940.09, and 940.10 all have the word homicide, except that one has the word murder. There are other offenses listed, including mutilating a corpse, assisted suicide. We have abortion exception, partial birth abortion, all under there. And I am by no means getting into a discussion about whether any of those things are a homicide or not, other than to note that the definition, if you go all the way to 939, and words and phrases defined, which is point 22. So 939.22, it defines human being when used in the homicide sections means ones who has been born alive. So again, I'm not here to debate any of that other than to note I can understand why all of those things would be listed under life. But for purposes of the lesser included statutes and really just looking at how Wisconsin law defines human life, there's a reason why some include homicide and some do not. That's really all I want to put or say about that. And we know from looking at the case law and the statute itself that, and I referenced this earlier, for example, mutilating a corpse would not be a lesser included. It's not any form of homicide. So for this court to say that just because assisted suicide falls under subchapter 1 and therefore is a type of homicide is not supported by the statute itself and the context and the clues and the headings that we have. But I looked further than that. And it's really important that we look at the definitions under Wisconsin law for both suicide and homicide. So suicide is the voluntary and intentional taking of one's own life, whereas a homicide is where another person intentionally causes the death of another human being. Assisted means, and again, really quoting here from the jury instructions, that a defendant intentionally, in some method or manner, helps or aids another to commit suicide. And when you look at homicide, it's cause. So it's a very big difference in the statutes themselves and how one violates those statutes. Assisting is not causing from a legal perspective. And so not only is suicide not a homicide, because suicide is the voluntary and intentional taking of one's own life, and a homicide is the causing of the death of another human being, assisted suicide cannot be a homicide for purposes of the lesser included statute because it concerns helping or aiding and not causing. But even if this court were to consider assisted suicide as a type of criminal suicide, my finding would be no different, that it's not appropriate to instruct the jury in this case, primarily because there's a denial of intentional behavior related to Lynn Hernan's death by Ms. Kurczewski. Now, of course, I don't just look at isolated statements. I need to look at the evidence as a whole, and would there be a reasonable basis? And I know that there is case law to suggest or to say that if a court is in doubt, you should give the lesser included. But the standard also isn't any evidence. It's whether there's a reasonable basis to acquit on the more serious charge and convict on the lesser charge. And there is just no support on the record before me that, and I'm really focusing on the third element of assisted suicide, that Ms. Kurczewski provided assistance with the intent that Lynn Hernan take her own life. On the contrary, there's evidence, and I think a reasonable view of the evidence is that she did not believe the tetrahydrozoline would kill Ms. Hernan. So that is my ruling as it relates to the defense request for the lesser included. I will deny the request to include that, and I will not be instructing the jury on assisted suicide as a lesser included offense. I do not believe, for the reasons that I've stated, that it is supported by the statute or the law in other respects, understanding that there is no Wisconsin case that has directly answered question number 1. I want to add that when I considered this a little bit more on how I looked at the reasonable, basis to convict on assisted suicide, I acknowledge that with element number 1, there certainly could be a reasonable view of the evidence as it relates to that element that Lynn Hernan committed suicide. I think even when looking at element number 2, when looking at what assist means, and that's to, in some method or manner, help or aid the deceased to commit suicide, I think there could be some. It's really that third element that I do not believe even a reasonable view of the evidence supports. Including what I said earlier about Ms. Kurczewski claiming to not know it would kill someone, her statements such as, had I known, I would not have left. Her intent to appease the victim and the evidence around that there's not a reasonable view that appeasement was for the intent that Lynn Hernan kill herself. The detective's statements and questioning whether it be their belief or just the way they did the questions and pushing, my word, Ms. Kurczewski, kind of confronting her with their belief about assisted suicide is not enough. Her and I further dug, and there's cases to support me doing this, so first of all, her exculpatory type statements cannot be the basis to support a conviction on assisted suicide. By that, I mean exculpatory in the sense of her denying either intentional acts and just knowing or claiming that she was suicidal would not be enough. I have to look at the other evidence and that's in the record. And I'm aware that even if there's some contradictory, positions, again, going back to that standard, as long as there's a reasonable view and supports a conviction on the lesser, but I'll acknowledge that I think under that particular analysis, it's a much closer call, but for the reasons that I've just stated, I still cannot find that there's a reasonable basis for that. Again, somewhat of an academic exercise because of the way that I answered question number 1, but I also thought it important to put that on the record as well. With that, Attorney Kukler, is there a request from the defense that the jury be instructed on any other lesser included offenses?
No.
All right, then I will not go through any analysis then as it relates to that. I realize we do need to provide then the parties with a final version for approval and then the verdicts as well. Where are you at with that, madam? So it would just be the first version of 1018 that we had. No bridging, no alternate. And then when we get to the very last part of my pages got a little bit out of order. Here we go. As to count one, it would be the standard verdict questions that we have with the not guilty first, followed by the guilty. And then I believe we have the verdicts already approved, right, as to counts 2 and 3, notwithstanding the objection by defense on some of the language. Is that right?
Yes.
Yes, that's right.
Any other instructions that you've perhaps thought about over the lunch hour that you want me to include, or any other modifications or edits?
Not from the state. Thank you.
No, thank you.
All right, as soon as Madam Clerk has that, I'll have it emailed, or we can just simply put it up on the screen and just kind of scroll through it just to see and get final approval. Yep. Do you want to put it up for all of us?
I put it on the preview book. Sure.
Sometimes I find it's easier to read those. Why don't you just go back up to the, so she can see, go back up to the, we all can see, I should say. Actually, the very beginning.
Okay. Still looking.
All right, just so you can see, I don't put the case number on for the jury.
Okay.
Any objection to that from the state,
No.
from the defense?
No.
All right, one is page 1 we've already talked about. So here is the beginning of the first count of the information. It's the standard 1018, notwithstanding the request from the defense, though, do you approve as to the language?
Yes.
Page 1, or this page looks fine.
Here's page 3.
That page looks fine too.
Okay.
That's a little bit probably there.
Hold on, do you see what she did?
Yes.
So that it says theft of movable property in the heading to be consistent with the verdict forms.
Right.
Thank you.
Any objection from the state,
No.
from the defense?
No.
Okay. And then here's, whoops, go back up a little, count 3. Again, the heading theft was changed to theft of movable property to be consistent with the verdict forms. Let me know when we can scroll down.
We'll just need to do a little formatting and change that. Original language.
Yes, that's the original language, other than it says theft of movable property and not just theft.
Well, there's one or two things that we changed between the drafts that I'll have to tweak again.
Oh, what else did we change?
There was like changing the one thing to in 2010, so I'll just go and make sure that
Oh, that's good enough. Okay.
Did you get the highlight out of there?
I did.
Okay.
Could I? There's a funny parentheses after the must under reasonable hypothesis.
That's I think that's my cursor.
Yes.
It's her
Oh.
cursor.
Oh, okay, got it. All right.
Okay.
Yeah, that's right.
Well, with none, nope, we all approved this earlier. Nothing changed with that. So you keep going. Keep going.
I need to add the 2010 thing back in.
But that's the other acts. If you want
Yeah,
to,
that's just, I think that's the only main difference here.
That's the cautionary. You're not to it yet. You got one more to go.
There we go.
Yep. So it should say that in 2010. Did you need my notes on that, or do you think you're good?
I have it in another document. I just was monkeying with that.
Got it.
But it should say
But
that
then
in
it's
2010, actually. Teresa, Madam Clerk, if you could put the word in before 2010,
Yeah, no comma, and then
no
just
comma,
No comment?
no comma.
and no comma after 2010 either.
2010. And attempted. Yep, you got that in. Attempted, both.
Am I okay to scroll?
Yep,
Yes.
so
Yes.
when you get to, hold on,
We didn't mess with that.
we did not. Did you have the changes to a defendant elects not to testify, or is that in a different spot?
That's coming up, but I need to make it the same as the other one and just add the cautionary statement
Okay,
heading, which isn't in this one. Going back to what was
Does that say that?
okay.
Can you slow down for 1 minute,
Sorry.
please? Yeah, do we say may not above, but now we say you may consider this evidence, or we say we may not consider it above?
What are you talking about?
You may, right there, you may not consider this evidence.
You may consider this only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense, should be offenses, by the way, plural, charged. That's the standard language. Other than adding the description.
They had to decide earlier in the case.
All right, so. Oh, we're in defendant elects. Okay, you can, there was no changes made to the one you're on. So go down to defendant elects to testify and then take out,
Can we say, instead of the defendant's decision in that second paragraph, can we say Ms. Kurczewski's decision?
these are standard instructions. And so they need to be consistent. Since we're not doing instructions until Monday, are you requesting that I change all references from the defendant to Jessy Kurczewski?
I was just asking for it in that particular spot.
Can you go back up, Teresa? I know you're trying to do what you're doing, but stay where we're at.
Just in the second paragraph there.
You want, instead of, okay, any objection to that?
No.
Okay, so Teresa down there, yep. How would you like it to read?
Ms. Kurczewski's decision. Thank you.
Okay, and then it says cautionary. All right, that should be good. Exhibits should be good. Teresa, let's see. Numbered jury, just make sure you have that one out. Coming up in a little bit. I think you did already. None of this changed.
Unless you're taking it out of earlier than already.
Mhm. And then can you do a page break where it says verdicts? Because I read that after.
There won't be 5 forms, that's incorrect.
So it'll be 6.
6
Like I
forms.
said, I have to fix count 1 to the
Yeah.
other way, so.
Just
it'll be
need to
6 then.
switch the 6, 5
Yeah,
to 6.
I'll have to monkey with that a bit.
All right, I'll have Teresa finalize this, email to the parties. I think generally where we need to be. I won't have her, you can take that down, finish doing that, but it'll get emailed to the parties. You'll have that opportunity to review it. Feel free to, Teresa, include me on the email because I have access to it. And if there are any things that come up over the weekend, I could go in and change it upon agreement of the parties. If there's anything else that you see, we'll make sure with the email will be all the separate verdict forms so that very quickly Monday morning, we can just do a final, we've reviewed it and approve of it. Okay. I don't think I've overlooked anything, but anything else from the state?
Oh, thank you, Your Honor.
Anything else from the defense?
No, thank you.
All right. Thank you, everyone. That concludes the hearing. Good luck as you prepare your closing arguments. I look forward to watching them, and I will see you Monday morning at 8:30.
Thanks, Judge. Have a good weekend.
Thank you. You too. We are in recess.
Okay, well, that concludes the jury conference. And I just wanted to pull up a blast from the past with Judge Dorow. Just bear with me for just a sec here. Okay. This is from a year ago with Judge Dorow here.
But it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that.
Oh, you got it. I changed,
Hold on. 76, the 76 count. Just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, 172 at the end because it was short.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom. I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Okay, on that note, I guess we'll end it. And we will come back on Monday for closing arguments and verdict watch. And maybe we'll watch some highlights of Dorow Brooks' worst antics in Judge Dorow's courtroom. She is just so incredible. Yeah. So, everybody have a wonderful weekend, and we'll see you Monday. So that's going to be great. Okay, we'll see you then. Bye-bye.